tries to help cable companies avoid state consumer protection rules. The Federal Communications Commission is intervening in a court case in order to help Charter Communications avoid utility-style consumer protections related to its phone service in Minnesota. The FCC and Charter both want to avoid a precedent that could lead other states to impose stricter consumer protection rules on VoIP, Voice over Internet Protocol, phone service offered by cable companies. The FCC has never definitively settled the regulatory status of VoIP. By contrast, traditional landline phone service and mobile phone service are both classified as telecommunications services by the FCC, a distinction that places them under the same Title II common carrier regulatory framework that applies to broadband internet access. But the FCC has never decided whether VoIP services offered by cable companies are telecommunications or information services, which aren't as heavily regulated. The Minnesota Public Utilities Commission, MPUC, hoped to fill this regulatory void by trying to reimpose utility rules on Charter Spectrum phone service. Charter used to be subject to Minnesota's utility rules but evaded them starting in 2013 by transferring its phone customers to a different subsidiary. Minnesota wants Charter to collect fees from customers in order to contribute to state programs that help poor people and the hearing-impaired access telephone service. Customers should also be able to appeal to the MPUC in the event of disputes with Charter, the state regulatory body says. Further reading, Comcast asks the FCC to prohibit states from enforcing net neutrality. The FCC is trying to prevent that from happening. The Minnesota PUC's sweeping demand that Charter comply with the state's full panoply of legacy telephone regulations, even though the FCC has not classified VoIP as a telecommunications service, threatens to disrupt the national voice services market, the FCC said on October 27 in an amicus brief supporting Charter. The court case is being decided as the telecom industry steps up pressure on FCC Chairman Ajit Pai to preempt state regulations. For example, Comcast and Verizon have asked the FCC to prevent states from imposing net neutrality rules and other regulations on broadband service. In the VoIP case, Charter beat the Minnesota PUC at the U.S. District Court level, and Minnesota appealed to the U.S. Court of Appeals for the Eighth Circuit. Though the Eighth Circuit handles cases from just 7 states, the FCC says the case has nationwide ramifications. The potential ramifications of the PUC's actions here extend far beyond the confines of Minnesota. A judicial declaration that VoIP is a telecommunications service, which is what appellants seek in this appeal, could potentially subject VoIP providers not only to Minnesota's state regulatory scheme, but also to the full panoply of federal common carriage requirements found in Title II of the Communications Act. And if the Minnesota PUC's efforts to regulate VoIP service were upheld, all 50 states could potentially seek to impose a patchwork of separate and potentially conflicting requirements on VoIP service. The FCC justified its inaction on VoIP by noting that it regulates aspects of VoIP despite never classifying it as either telecommunications or an information service. For example, the FCC imposes requirements on VoIP related to 911, customer privacy, accessibility and funding for people with disabilities, and universal service contributions. Virtually all meaningful consumer protection would be eliminated. The Minnesota case is the first opportunity for a federal court of appeals to address the question of whether VoIP is an information service or telecommunications under federal law. A brief filed by AT&T, Verizon, and the trade group Estelecom said. Consumer groups warned that a Charter victory would bring the loss of consumer protection rules that guarantee universal access to basic telephone service at fair prices. Virtually all meaningful consumer protection would be eliminated, argued Mid-Minnesota Legal Aid, a non-profit law firm for poor people, seniors, and people with disabilities. Undue price, geographical, and other discrimination would become unrestricted, threatening the availability and maintenance of these indisputably essential services. A court filing by the Minnesota PUC explains how Charter evaded the state's utility rules. Charter's phone service in Minnesota used to be provided through a subsidiary called Charter FiberLink, which is regulated by the state as a telecommunications company. Despite using VoIP technology, it was regulated like a traditional phone company until 2013. As an authorized competitive local exchange carrier, CLEC, Charter FiberLink is required to comply with the consumer protection requirements under Minnesota law, the state's legal filing explains. But in March 2013, MPUC says Charter unilaterally transferred all its